Be ready. Start. The principal question in that case was whether the magistrate could drop the proceedings after filing of a report under section 173(2) without notice to the complainant. But in paragraph 4 of the judgment, the three-judge bench dealt with the powers of the magistrate as enshrined in section 173 of the code. Now, when the report forwarded by the officer in charge of a police station to the magistrate under subsection 2(1) of section 173 comes up for consideration by the magistrate, one of two different situations may arise. The report may conclude that an offence appears to have been committed by a particular person or persons, and in such a case the magistrate may do one of three things. 1. He may accept the report and take cognizance of the offence and issue process, or 2. He may disagree with the report and drop the proceeding, or 3. He may direct further investigation under subsection 3 of section 156 and require the police to make a further report. The report may, on the other hand, state that in the opinion of the police, no offence appears to have been committed, and where such a report has been made, the magistrate again has an option to adopt one of three courses. 1. He may accept the report and drop the proceedings, or 2. He may disagree with the report and taking the view that there is sufficient ground for proceeding further, take cognizance of the offence and issue process, or 3. He may direct further investigation to be made by the police under subsection 3 of section 156. Where, in either of these two situations, the magistrate decides to take cognizance of the offence and to issue process, the informant is not prejudicially affected, nor is the injured, or in case of death, any relative of the deceased aggrieved, because cognizance of the offence is taken by the magistrate and it is decided by the magistrate that the case shall proceed. But if the magistrate decides that there is no sufficient ground for proceeding further and drop the proceeding, or takes the view that though there is sufficient ground for proceeding against some, there is no sufficient ground for proceeding against others mentioned in the first information report, the informant would certainly be prejudiced, because the first information report lodged by him would have failed of its purpose wholly or in part. Moreover, when the interest of the informant in prompt and effective action being taken on the first information report lodged by him is clearly recognized by the provisions contained in subsection 2 of section 154, subsection 2 of section 157, and subsection 2(2) of section 173, it must be presumed that the informant would equally be interested in seeing that the magistrate takes cognizance of the offence and issues process, because that would be culmination of the first information report lodged by him. There can therefore be no doubt that when on a consideration of the report made by the officer in charge of a police station under subsection 2(1) of section 173, the magistrate is not inclined to take cognizance of the offence and issue process, the informant must be given an opportunity of being heard so that he can make his submissions to persuade the magistrate to take cognizance of the offence and issue process. We are accordingly of the view that in a case where the magistrate to whom a report is forwarded under subsection 2 1 of section 173 decides not to take cognizance of the offence and to drop the proceeding, or takes the view that there is no sufficient ground for proceeding against some of the persons mentioned in the first information report, the magistrate must give notice to the informant and provide him an opportunity to be heard at the time of consideration of the report. It was urged before us on behalf of the respondents that if in such a case notice is required to be given to the informant, it might result in unnecessary delay on account of the difficulty of effecting service of the notice on the informant. But we do not think this can be regarded as a valid objection against the view we are taking, because in any case the action taken by the police on the first information report has to be communicated to the informant, and a copy of the report has to be supplied to him under subsection 2 1 of section 173. And if that be so, we do not see any reason why it should be difficult to serve notice of the consideration of the report on the informant. Thank you.